good afternoon or morning, whatever the case may be in your particular time zone. Thank everybody for joining us. I'm Eric Boughman. I'm a founding partner and attorney at Forster Boughman. We're a Florida law firm where we specialize in business and healthcare. Over the next hour, I'm going to walk through the eight decisions or eight of the major decisions that you need to cover when opening a healthcare practice in Florida. Some of this can apply outside of Florida as well, but we're Florida focused as that's where our practice is. I'm also licensed outside the state in Nevada and can do work in other places. But for the most part, we'll focus on federal and Florida law and some of the business decisions that you need to make. If you're planning to open a practice in the next within the next 6 to 12 months, the law changes on some of these issues, and we try to keep pace with that. But if you're planning on opening in the next 6 to 12 months, this will give you a good guide for what you need to address and why it's important. As far as the how of doing it, that's a little more nuanced and detailed, and we may present some options to you throughout the webinar for how you can cover those issues. All right, with no further ado, all right, these are the 8 decision areas that we're going to cover today. And this is essentially in the order that they need to happen. And the first decision is, what are you actually building? And a lot of times folks skip past this and they jump into creating the entity and start working on the practice itself. And what we really need to do when we start building the practice is figure out what's the path going to be. And it's not going to be the same for everybody. A lot of it has to do with what you're trying to shape from the beginning. So the first step is what we're building, and then each step builds on top of that. And once you start to build, then we'll talk about how you operate, how you get paid, the operations dealing with people and the patients and vendors and employees and so forth in the practice. And then we'll talk about growth, some of the risks and some risk management as you grow and expand, and an operation or options rather to bring in partners, bring in potentially investors, if you want to grow and expand and scale the practice beyond just a small startup. So we'll start with number 1. And this is the first decision is it not necessarily what entity to form, but what practice model you're actually building. The business model will drive the entity choice, the licensing path, the payer strategy, staffing and marketing issues, and the risk profile. And skipping this step in the beginning and moving right into the entity can sometimes create issues later down the road. Let me give you a scenario. Let's say you start, a lot of folks come in and they come to talk to me, or they'll come into the firm, or we'll get on a call or a Zoom, and they'll say, well, I've already created a PC, or I've created an entity, and I need help with putting pieces together to start the practice. Well, let's take that decision. I'm going to give you a very common scenario. You're a healthcare professional, and you create a professional corporation to operate your business, and you operate in Florida under an exception under the Healthcare Clinic Act. So you don't need a clinic license because it's wholly owned by you as the professional. It's a PC model, which is essentially a professional corporation, which operates in Florida similar to a regular corporation. And let's say separate from the practice, you lend out your vehicle and somebody gets in a car accident. You end up getting sued because you're the owner of the vehicle. And this is more common. This is probably the most common form of liability that I see among clients in the law practice. It's not professional claims and liability. It's not partnerships disputes, although those come up sometimes, issues with employees, contractors. The most common has to do with auto accidents. We don't deal with auto accidents. We don't do insurance defense, but I have clients who end up becoming defendants in lawsuits because they've either been in an accident or their spouse is, or they own a vehicle and they've lent it to somebody, a child or someone else who's been in an accident. Now you get sued. Let's say you have insufficient insurance. So maybe you've got a $1 million claim and you've got 25,000 for whatever reason. You have minimum amount of insurance. Now you have a potential excess liability claim. You have your practice, which is totally separate from this and has nothing to do with the accident at all. It's not a vehicle that's owned by the practice. Now the creditor goes forward to get a judgment, and let's say a creditor gets a judgment against you. Now they're looking for assets they can seize. One of the assets they can seize is your shareholder interest in your PC that operates your practice. Not only does that destroy your ownership interest in the practice and take that away from you, which is the way you probably make a living. It affects licensure status, even if you have other, let's say you're in business and you have two partners and you operate through the PC, through a professional corporation or a regular corporation. And now you have a creditor from a car accident who seizes that interest and now becomes an interest holder in the practice. And the practice was operating with only licensed professionals, so you didn't need an ACA healthcare clinic license. You've now destroyed your ability to maintain that exception, and you have an unlicensed practice. Now the practice can't get paid. It affects your ability to receive payment from payers and your ability to continue to operate. That's a very common scenario that I just ran through. And that all stems from just simply setting up the practice incorrectly. So when we talk about the beginning setup, we have to know what kind of practice you're building and what type of model you're going to pursue. And the issues that you're going to look at are your practice model, if you're going to be solo, if you're going to be in a group, what type of practice becomes important, especially when we talk about who the professional is. For physicians, they typically can operate anywhere in their scope of practice and don't have to worry about separate ACA licensing issues. For physician assistants, who we represent sometimes in our practice, that have independent practices, they operate through a business under physician protocols. And for the advanced practice registered nurses who have the ability to work autonomously in Florida since 2020 rule changes, there's a common misconception that because you have autonomous practice rights, you can operate in all of these different practices, these different operations and specialties without physician oversight. And that's quite candidly not what the statute allows, is you to operate a primary care practice autonomously, assuming you meet the requirements, 3,000 hours and the required training. But then you have the question of whether operating a med spa, for instance, which has become very popular, or an IV hydration clinic, or a hormone or a weight loss clinic, are these the types of practices that you can operate autonomously without physician oversight? And I would be very cautious. I've had some folks come to me with specific practice models, say, for instance, dermatology. Well, if you're a nurse practitioner and you want to operate as an autonomous practice, is dermatology within your scope of practice? Is that considered primary care? I think that's a tough argument to make. If you are doing weight loss, for instance, I think it's an easier position to take, that weight loss is part of health management, that's part of primary care. Just want you to be aware that these are questions that you need to address from the beginning. And you don't want to run into issues where you find out that you're operating without a license, because that can lead to other issues, particularly payment. If you are operating and you're not properly licensed, and your payer, an insurance company, takes the position that you're not providing services under a properly licensed regime, the payer can come back later and try to recoup payments from you, and they can look back for years. And in my mediation practice, separate from the law practice, I do a lot of mediations with third-party payers, with insurance companies who do go back after healthcare practices, practitioners, medical directors, owners, and try to recoup payments, oftentimes in the millions of dollars. And a lot of times it's because the payments weren't properly rendered, because the licensing was not proper at the time, or the payments were not proper because it was not proper licensing. So I want you to be aware of these issues, and this is the first discussion that really needs to take place. What type of practice are we going to have? And that's going to dictate everything else that we do around the practice. Common mistake is, again, starting with filing your LLC or your PC, and we'll talk about that in a moment, what the difference is, without first deciding what type of practice you're going to have. After we make that decision, we move into step two, which is your entity ownership. And I have this discussion a lot with folks. What type of entity and how does that affect tax status, asset protection? Now, full disclosure, I'm not a tax attorney. My partner is. A lot of tax issues, we typically refer those back to the accountant, but the entity that you pick will oftentimes dictate at least what your default status is for tax. Interesting note here is some states require a professional, a lawyer, a healthcare practitioner to operate through a PLLC or a PC, a professional corporation or LLC. Florida does not. Those are essentially, in Florida, they're essentially antiquated models. There are some reasons sometimes to do that because the ownership is restricted to those particular professionals. But in Florida, the most common is an LLC. Now, why an LLC? Let's go on here. We'll talk about the LLC versus the corporation. The example that I used a few minutes ago was the PC, the professional corporation, and how that professional corporate interest can be seized by a creditor. That was the car accident example I gave you. You don't have the same situation when it comes to an LLC in Florida and generally in any jurisdiction. And in Florida, if it's a properly structured LLC, now you have sometimes an issue with single member, but multi-member LLC, let's say two or more partners in business. And the reason why is that the LLC enjoys what's called charging order protection. And what that means is that a creditor that has an interest against an individual, if somebody has a claim against you, the creditor cannot seize an LLC interest from that you own in a multi-member LLC. It could be with you and a spouse, you and a partner. And by the way, spouse, sibling, parent fits into the wholly owned practice exception in Florida for ACA licensing. So you own that entity as a multi-member entity. A creditor who gets a claim against you can only get what's called a charging order. That means they can get an interest against any distributions that are paid out of the entity if and when they're paid, but they can't seize the interest. They can't take control. They can't take ownership. They get no voting. If you have a properly written operating agreement, we cover all this. When we set up the entity, we set up the operating agreement, and we restrict any rights of any creditors. And the law provides support for that so that the creditor can't come in and make any decisions or take ownership. That saves your licensing. And that's a huge decision. A lot of people just sort of skip over if they go themselves on Sunbiz and file something without really thinking through what type of ownership they're going to have, what type of entity, and who the owners of that entity are going to be. So in Florida, the question of what type of entity you have is really, it becomes a regulatory question more than just an entity question. And the asset protection benefit, the protections inside the entity are the same for the corporation or for the LLC. Anything that happens in the entity does not stem to you as an owner unless you're directly involved. So there's some exceptions to that. One is if you personally guarantee something. Two, if you personally provide the services. But if you have, let's say, you have an entity or practice and there's a slip and fall or something else happens, or there's another clinician who does something wrong in the entity can get sued. The individual providing the service can get sued, but you, just by virtue of your ownership interest, you don't get sued again unless you are directly involved or unless you have signed a guarantee. The other direction, creditors coming from the outside in, creditors against you individually, so one angle of asset protection is what happens inside the business, inside the entity. The other angle is outside. That is fully exposed when it comes to corporations and some single member LLCs. Multi-member LLCs, we avoid that outside exposure. Later, we'll talk about a little bit more complex structures when we get into MSOs and the friendly PC model. We'll talk about that growth and expansion. Let me go back one other point on the entity issue. When you select your entity, the way that it's set up is essentially going to create your default tax regime, but we will always refer you to speak with your accountant about how you want to be treated for tax purposes. If you set up a single member LLC, the default typically is a disregarded entity. You can get a separate EIN. It's recommended that you do so. Some folks will want to set that up as an S corp, but that's a special election that you need to make. If you set up two or more members of an LLC, the default regime there is going to be a partnership. So you file a 1065 return. Again, you can override the default and choose to be treated as an S. You can also choose to be treated as a C. People don't usually typically do that. If you set up a corporation, which again, we generally don't recommend because of the additional exposure, your default is typically going to be taxed as a C corp, but you could elect S. So the LLC allows you to be S, allows you to be disregarded if it's single member, allows you to be partnership. It also allows you to be C if you make that election through your accountant. So it gives you the most flexibility. Want you to be aware of that because when people do this on their own, or if they go out and just get an EIN and they have two or more members, they find out often by surprise in sometime around April or May of the following year, even if they weren't operating, that their first tax return for the partnership, the 1065 return, was due in March. And that's a very common mistake. And so when we're setting things up, we want to make sure you're aware of that and don't run into that issue. All right. Now we're going to talk about really what's one of the highest stakes sections in this webinar. And in this case, the most Florida specific. Operating an unlicensed clinic in Florida can result in felony exposure. And when you bill third-party payers from a clinic, it creates the recoupment risk we talked about earlier, where payers can come back even after a number of years and try to recoup any payments that were made to the improperly operating clinic. There's also a question when you have your ACA license, if you apply for the license, what's the role of the medical director? Who can serve as a medical director? I've done a whole separate webinar. You could probably find an old one on YouTube. It's probably time to refresh that on the duties and obligations and the potential risks for a medical director. Just know that it's got to be something more than just a figurehead director. You have to, the medical director, when they sign up for that role, is taking on significant responsibility for all the patient records, for the billings, for oversight of operation of the clinic. If you are a licensed clinician and you fit into the exception under the Healthcare Clinic Act for ownership, then you will not need or may not need a medical director. That's a decision that should be made after careful legal review. There are sometimes clinicians who would qualify for that exemption, but there may be reasons why, for instance, doing things outside scope of practice. If you would qualify for the exception, but you're going to operate outside your scope of practice, then you may want to go and get your license, or if you're going to have multiple practices, it may make sense to get separate ACA licenses and get medical directors for those. All right, so we have essentially in this webinar and the calls we get generally come from a few different directions. It can be physicians or autonomous practice, primary care, nurse practitioners. It can be nurse practitioners or physicians or PAs who operate clearly within their scope of practice. Those who are operating in areas that may not be clearly within their scope of practice. And then the physicians themselves. So it really breaks down into the nurse practitioners, PAs, physicians, and we also may have some folks here that want to own a medical practice, but they're not a licensed clinician. Those folks will need to typically operate the practice with a healthcare clinic license and get a medical director in place, have a medical director agreement, and meet those requirements. There's also the MSO. Again, I mentioned that earlier. That's more of an investment type joint venture. We'll touch on that a little bit at the end. That's its own specialty area. The three essentially directions or three orientations of this section depend on who you are. And if you're in the first group here on the slide, then some of what we're going to talk about you won't need. If you're in the second group, and you're working either if you're a PA or not qualified for autonomous practice, working outside your scope of practice, then you're definitely going to need to work at least under a physician's protocols. And so we can help you. We do that regularly, set up the protocols. So you'll have a physician protocol in place that needs to be filed with the state. both on the physician side and on the clinician. And physicians who do that, whether you're serving as a medical director or serving as an oversight physician for the protocols with an assistant or a nurse practitioner, need to realize that you have additional responsibility. Particularly similar to the car example, if you are the medical director for a practice, or if you're the oversight physician and something goes wrong with the treatment, you're probably going to be on the hook. You want to make sure you have insurance in place for that, and the insurance covers you for those activities. Now, the Healthcare Clinic Act itself, under Chapter 400, and the most commonly used exemption, as I mentioned earlier, is the wholly owned exemption, where a licensed healthcare practitioner owns the practice, either themselves or with a partner clinician, or a spouse or other relative who qualifies under 400.9905 sub 4. And the exemption can sometimes be very fact specific and depend on who owns and provides the services. If you are owning with a spouse, the owner, the licensed spouse needs to be the person who is responsible for oversight of the practice. But it can be a good idea to bring a spouse in as a partial owner of that practice, because it then creates the two-member LLC protection that we talked about earlier. Or you bring in other clinicians and you partner up with somebody else. Again, you create a multi-member LLC or PLLC, and that creates the asset protection that prevents you from running into a situation where some outside event puts your license at risk. The scope of practice here, I just want to touch on an issue that comes up a lot, and you need to take a look at the language. And it was the House bill that was passed in 2020, and 464.0123, that designates primary care for nurse practitioners as the eligible practice area for autonomous practice. So if you're planning on doing something that falls out of the definition of primary care, now, admittedly, that's maybe some gray area. Again, is weight loss primary care? Probably yes. Is hormone therapy, IV therapy, med spa primary care? You get into Botox, potential dermatology issues. Now you're moving further away from that. That's going to be a very fact-specific question, and you really need to take a hard look at that before you move into that practice area. And that's probably one of the most common issues that we deal with. Now, the medical director question. The arrangement that often fails under scrutiny is what we call figurehead medical director. The physician who's paid a flat monthly fee, doesn't visit the clinic, doesn't sign documents, has no operational role. And this is an arrangement that creates exposure for the clinic and for the physician serving in that role, both under state law and under federal anti-kickback rules. If you're taking Medicare or Medicaid, any type of state funding, taking VA funding, anything that comes from the federal government in whole or in part exposes you to federal regulations. And the kickback rule can apply because if a regulator looks at the practice and says, well, the physician's not really providing any services, they're just being paid. And I've actually had people tell me this. Well, we have the medical director because it helps us bring in patients. So we have a medical director. Any arrangement where it's an arrangement set up to create an opportunity for billing patients, and that person's not actually providing fair market value services, which the figurehead medical director could fall into that role. They're not providing services that match the value, or that are not fair market value. Instead, they're based on value or volume of referrals, or they're there and they don't provide fair market value. That can create a kickback issue, open up the doors to other regulatory issues. The common mistake that we see is assuming that because the owner is licensed, the clinic automatically qualifies for an exemption. Again, if it's not within your specialty area, then you need to take a look at whether or not you need to get a medical director who does cover that specialty practice area, or or have somebody in the clinic who's providing services that are within their scope of practice, and whether or not that question leads you to need a medical director. All right, we move into section 4. This is how you get paid. Credentialing is essentially how payers recognize you, the clinician, so you can bill and collect for services. This is not an optional step. This is something you will need to do if you intend to accept insurance. And you really need to get the sequencing right here, because if you don't have your credentialing in place, you could go months without getting paid and end up having a bunch of business-related expenses with no way to cover them from money coming in until the credentialing and approval process is complete, until you're enrolled with the necessary payers. Candidly, this is probably the most practical section of this webinar, and we'll give you a little bit of the background and tell you the steps that you need to follow. This will be familiar to some of our professionals, but this is a good checklist. And by the way, with the materials, with the seminar materials today, we have given you a checklist for opening that covers the issues that you need to address when you're opening, in addition to some presentation materials. So first step is your NPI. So you got two types, and people often get confused on this. Type 1 goes to the individual clinician, a person providing services. Type 1 follows you forever. It's like your driver's license. Think of that analogy. You get one NPI, you move to a different location, you carry that NPI with you, your personal NPI. Type 2 goes to the entity, and this can change. So consider type 1 is the driver's license, type 2 is the vehicle license plate or registration. And when you make a claim through insurance, you typically use both. You have the provider of the services under type 1, and then who gets paid for the services under type 2. So if you work in a hospital setting or work in a group setting, or even on your own, you bill under your own NPI, and then the payment is rendered to the type 2 to the business NPI. And if you start a new practice, if you move somewhere else, then you'll operate with a different, either the new practice will have its own NPI, or you start with a new NPI. The way you now set yourself up to get credentialed with different insurance payers is through the database that's at the Council for Affordable Quality Healthcare, CAQH, your profile there. You set up all your information, and the idea is supposed to make it easier for clinicians to register once in that database. You have a duty to keep that database to attest and keep it active. So you have to go in at least every 120 days, reattest to the information being correct. And that has all of your background information in there, including information about your license, your practice. If you have any open claims, any issues with your license, those will be recorded in there. And then once you have that information loaded in, that's the information that the payers are going to want to look at as you apply for specific payers to enroll with those payers in your practice area. What I want you to take away from this part is that the enrollment isn't automatic, and the enrollment doesn't happen right away. There are situations, I know there's some counties in Florida, for instance, that have, and this happens a lot with Medicare Advantage and some other plans, where there's essentially they're full. They don't need any other providers, and so they're not taking on other providers. And so you may start the practice thinking, okay, I'm going to enroll in this plan and this plan and this plan, and whatever ones you pick, Blue Cross and Aetna and Sunshine, and then you find out you go to enroll, and they say, well, we're not taking any new providers right now. You need to plan for that ahead of time. Look into this. Talk to somebody. I typically, this isn't something we typically do as lawyers unless there's a specific issue that comes up. But I work with some folks that I'm happy to refer to, who will know the nuances and know what's going on with the plans in each county, whether or not there's the enrollment's open or closed, what the timeframes are, what you can expect. So one is you don't necessarily get automatic enrollment, and two, it may take a lot longer than what you expect. You could be 90 to 120, 180 days. There's a separate process for Medicare and Medicaid. Understand, if you go with Medicare and Medicaid, these are more heavily regulated because it's money that comes from the federal government. Medicare, Medicaid also expose you to federal laws. Now, when we talk about things like the Stark Law and the anti-kickback statute, it doesn't really matter if you're not under Medicare or Medicaid because Florida, through the Patient Brokering Act and fee splitting rules, has its own version, probably more strict than the anti-kickback statute. So those rules still apply. We'll talk about those a little bit more towards the end when we talk about marketing and growth and some of the risk. Uh, but there are more issues to cover. If you're opening up a practice, you're not going to be cash pay. I have some clients that are cash pay, and if you build that practice, uh, they have a lot less regulatory issues. Once you're dealing with insurance companies, you're subject to the enrollment requirements, the contract requirements. You have to go through that with each of the providers. You have prepayment reviews sometimes. You have post-payment audits and reviews. Sometimes those post-payment audits can lead to recoupment demands. Sometimes the recoupment demands can be what's called extrapolated, so they come in much higher. I just represented a client for over 4 years. We've been dealing with a situation where they had a recoupment demand and it was a podiatrist, and it ended up being over $900,000. Luckily, after 4 rounds of appeal, we got a favorable decision. But in the 4 years while that's been going on, he hasn't been able to collect any revenue, any payments from Medicare. They've all been held up because Medicare has been insisting that he owes them money. Turns out that it looks like we've got finally, after the 4th round of appeal, a successful result. But you need to be aware that that's a situation that can come up. If you're dealing with insurance where cash pay, you're just cash pay and patients come in, they pay, and you don't have the same issues. So keep that in mind and also keep the closed network in mind. All right. And let's talk a little bit about credentialing for nurse practitioners and some of the specific issues. One, know that when you are, if you're a nurse practitioner in autonomous practice, you could be billed at a lower rate at 85% instead of, or paid at a lower rate, 85% instead of 100. There are some circumstances under incident to billing rules where you bill at 100%, but those aren't very common, especially if you're on your own and in your own practice, you won't have that. Getting paid is half the battle. Once you've been paid, you're going to be, if you're dealing with insurance, you're going to be subject to post-payment audits and being able to respond to those audits, defending against claims that there are deficiencies in your audits, defending against recoupment demands. That's going to be another part of your practice. And it's going to be very important that your records support your billing. So not only your records for clinical purposes, but for record keeping and billing purposes, you're going to want to make sure your records meet the requirements that the payers expect to see when they audit the records. And you're going to have a plan in place for dealing with audit requests. So you know, and I've done an entire webinar on this, on dealing with audits, responding to audit requests, how to do that, how to document everything in a letter so that you keep a record of all the communication and everything you have provided to make sure that you've given everything that's necessary to avoid a recoupment demand. That's the worst is providing the services. I think it's one of the worst circumstances, providing the services, getting paid for the services, then finding out months later after you've given records that support that payment that there's some record deficiency or alleged deficiency with respect to the records, so that the payer claims that the services weren't medically necessary, and they say, we're not going to pay this. And not only we're not going to pay for these claims, but because these claims are defective, we're going to ask for additional repayment. And now you're looking at a six-figure recoupment demand. One of the most common mistakes is getting started in the practice, signing your lease, hiring people, getting an opening date, and then you're not properly credentialed, you're not set up properly to get paid, or you're not properly set up to get paid and have the record established, the record process established so that you can keep those payments. All right, topic 5. Next question, HIPAA, privacy, security, and a new addition of AI. Everybody's favorite topic. I know HIPAA is very dry. Here's what I want you to take away from today's webinar. Understand that HIPAA, it's not a compliance binder that you sit on the desk and you go through the steps. set it up, and it's one time and you're done. HIPAA imposes a continuous set of obligations across two different rules with a notification regime. And the most common mistake when it comes to HIPAA is just downloading a template policy, printing it off, sticking it on the shelf, and figuring that your compliance is done. It's an ongoing requirement. I have clients that I work with, there's notification requirements for issues, and you have to do regular trainings, regular audits. If you get into the process of doing that, set up a calendar for doing it, not overly complicated. There are companies that will do this. Typically, they're a little more expensive and designed for bigger organizations, but you can set up something yourself. I've helped clients set up compliance compliance calendars, and I actually have an example that I'm happy to share of a compliance calendar where you can make sure you're documenting all the information you need and staying on a compliant path. The issue with HIPAA is you have to have the right personnel designated, and you have to have policies. The templates don't perform risk analysis. The analysis has to be specific to your practice, the technology you have, and your workflows. Also, with respect to AI, most consumer or general purpose AI tools are not configured for HIPAA. You can't plug patient data into ChatGPT or any other consumer-facing model. I've read the privacy policies on most of the mainstream AI models, Gemini, ChatGPT, Claude. There are tools that you can get where where the models are compliant. The key is they need to sign a business associate agreement. I know that for SharePoint, I don't know about, I haven't looked at the AI for SharePoint, their tool, but I know that SharePoint in general will sign a business associate agreement. I believe Dropbox will, Box will. These are the cloud storage mechanisms, and there are tools. I believe that Claude will sign, if you get the business plan or the enterprise plan, you have to contact them directly. As I'm saying it out loud, it's probably something I'll do. But what I want you to take away from this is that anybody you're doing business with who has access, including think of this way. If you have a company that comes in and shreds your documents, they should sign a BAA. And anybody who has access to patient records should be documented, logged, including employees, contractors, vendors, and anybody outside the practice. Inside the practice, they should be signing at the very minimum a confidentiality agreement. You should have a workbook or an employee handbook in place so that they know that the information is confidential. They're subject to confidentiality requirements. And then outside the practice, any vendors need to sign a BAA. All right. People, this is one of my favorites. The people in and outside the practice, a clinical healthcare practice is essentially a small business with a disproportionately high regulatory exposure. The people inside, the vendors outside, and the professionals all around the practice create risk unless you structure properly. So some of the issues that we see on a regular basis, the employee versus independent contractor question. Some people want to open up the business. They don't want to take on employees. They don't want to deal with payroll taxes, payroll itself, workers' comp issues. So they say, okay, everybody's going to be an independent contractor. Well, you can have them sign independent contractor agreements. They can agree to get paid as an independent contractor, and you issue them a 1099 at the end of the year, and come to find out later that they're not really an independent contractor, that regardless of what you call them, the law considers them an employee. When that most often happens, it's not because suddenly the employee says, gosh, I read something, I think I should be treated, or but let's call them the worker. The worker decides that they should be treated as an employee. The worker thinks they've been treated unfairly, and they leave and they realize, well, they start talking to somebody, they end up talking to a lawyer, and the lawyer says, no, you were an employee. Now they get ready to make a wage claim because you paid them as an independent contractor, and maybe you told them, you should read this training material. You should take this HIPAA training to work in our practice, and you didn't pay them for the training time. They come back and they make a wage claim against you. Or somebody's injured, and now you have a workers' comp issue, and your regular insurance won't cover the issue because they say it's a workers' comp issue with an employee, but you don't have workers' comp insurance in place. These things pop up usually because there's some other issue that triggers it. I just want you to be aware that there's an open question. Simply calling somebody an independent contractor doesn't make it so. There's several different tests and they're very fact specific. There's a number of issues. A lot of it comes down to, are they subject to your control? Are they using their own tools? Or are they using yours? If you have somebody that's working in your practice every day from a set schedule, 9 to 1 or 9 to 5, Monday through Thursday, Monday through Friday, using your equipment, working in your facility, and you expect them to be in the chair, they're probably an employee. Also, many healthcare positions, anybody who's dealing with patients, often are going to be subject to level 2 background screening that involves an FBI check, fingerprinting. Just be aware of that. And then restrictive covenants. This is a big issue. A couple of years ago, there was a movement by the FTC to try and do away with restrictive covenants, covenants not to compete in particular. That one ended up being legally challenged, and as far as I know right now, is sort of an abatement. So as things stand today, non-competes are enforceable in Florida and in other states, and Florida in particular happens to be pretty stringent on enforcement of non-competes. I'm not a big fan of non-competes. I write them for clients. I've dealt with them. I've argued them over the years, both on behalf of the people subject to the non-compete and for the employer. Uh, my view is that most of what your concerns are when you're running a healthcare practice is you don't want people coming in, working for you, and then stealing your people or stealing your patients. And most of that can be dealt with through a non-solicitation or an anti-piracy type agreement that limits the right of anybody who works for you to leave and either take people from your practice or take contact patients or take patients. Even if the non-compete ban that the FTC had proposed would have passed, you would still be able to put most employees under a non-solicitation agreement. Uh, and then just understand that when it comes to hiring other clinicians, those are more specific requirements of what's going to be needed. Again, background checks. There's supervision issues, whether they can operate independently or operating under your supervision. If you are a physician and you're hiring PAs, nurse practitioners, other people, assistants, particularly if they're going to be billing, you need to be very cognizant of identifying the issues, uh, the proper way to handle the billing. All right, let's move on to the next one here. Sorry, I jumped the slide. All right, vendors outside the practice. As I mentioned earlier, anybody outside, any vendor should be signing a BAA. Your outside vendors, you have your EHR, billing, obviously even phones, your cloud storage, your email provider, payroll, bookkeeping, all of the regular services, marketing. We'll talk a little bit more about that. Marketing can get people in trouble because of fee splitting, kickback issues. Have them all sign BAAs. And then there's a few relationships you should have always outside of your practice, specifically a healthcare experienced attorney, healthcare experienced CPA, a credentialing consultant, and a professional liability insurance contact, somebody who knows the business. I recommend you work with a professional. I'm happy to make referrals in this regard to both the credentialing, the CPA, and the insurance professional, because I've seen situations where people try to take a shortcut, especially on insurance, and they try to skip that step or go with the cheapest available, and not working with a professional ends up getting them in trouble because when they need the insurance, it's not available because there's some loophole that the insurance company tries to avoid coverage. Don't put yourself in that position. Get somebody who knows what they're doing, give you good advice, get the proper liability insurance, cyber liability insurance, commercial general liability running your practice. There's different things you're going to need, workers' comp. Make sure you get those pieces in place. All right, so now on step 7, we're kind of tracking right on track here. I'm happy to take questions, by the way, during or after, or if we don't get to them today, if you want to reach out afterwards. Before the patients come in, you need to make sure you have documents in place to be able to service those patients, the requirements. And there are specific requirements that are pretty general that are required everywhere, and then Florida has its own requirements. There's operational policies, and there's certain records discipline that needs to hold up and be subject to review, be able to hold up under an audit. And if you try to create these things on the spot, if you wait until an issue happens and then you try to create these documents, it's going to be too late. This is your operational readiness section. So your patient-facing document set, uh, notice of privacy practices. The language for that generally is in the federal statutes. There's a language that we track to make sure that you have a HIPAA compliant notice of privacy practices. You also not only notice of privacy practices, but you have to make sure the patient signs an acknowledgement of having received that. Otherwise, you have no proof that they actually got it. Informed consent to treat. That depends on your practice. You need to give them the proper information about the potential risks of the practice and get the patient's consent. You should keep that for every patient you deal with. Financial responsibility policy. What happens if you're taking insurance and the insurance doesn't cover it? Do you have a mention in there about copays? I've had clients that get into disputes with patients, and we have to deal with state complaint because the clients are surprised that they have to pay copays, even though it shouldn't be a surprise. What about your cancellation policy? What if people make an appointment, they book up your calendar, and then they no-show? How do you treat that? That should be addressed in your financial responsibility policy. If you're doing of course, your assignment of benefits for insurance purposes, if there's any health payments and you provide the services, you want to make sure that you're the one who gets the payment for that. It doesn't go directly to the patient. If you're doing telehealth, you need to have a specific informed consent for telehealth so that you explain the risks, and this is in writing, explain the risks to the patient of using a telehealth platform and that they consent to it. I draft these all the time for clients. I combine some of these in particular the telehealth consent with the informed consent, because most practices nowadays are using telehealth sometimes or all the time. Here's another issue with telehealth. If you're doing telehealth practice and your patients are out of state, are you allowed to service them? If you have a patient who's in Georgia or North Carolina and you're not licensed there, the rule generally is that wherever the patient is where you need to be licensed. That's where the services are said to occur. So if you're setting up a practice I have some practices I've talked to and some that I work with who do a substantial amount and some that are exclusively telehealth. That's becoming a big thing with therapy services, for instance. If you're setting up a healthcare practice and you're doing everything through telehealth, you need to at least understand that there could be an issue with treating a patient outside the state of Florida. If the patient relationship originates in Florida and then they leave, if they come to visit you physically and then they leave, that becomes a different issue. Just be aware that that's an issue that you need to look at very closely. We talked a little bit about insurance. One issue that people get a little bit tripped up on, I want to cover just briefly here on insurance, is the two different types of professional liability coverage are your claims made versus your occurrence-based. Occurrence-based is your broader type of coverage. If there's coverage in place and there's an issue that happens with a patient, a liability issue or potential issue, the occurrence-based coverage will cover it if the coverage was in place at the time that issue occurred. Claims made coverage, understand that is a less robust coverage. Claims made only covers if the insurance is in place at the time that the incident occurred and the insurance is still in place at the time the claim is made. So you have to have two things in place there, the time of the event and the time the claim is made. If you had coverage last year and it was an event last year and 6 months or a year later, a patient makes a claim and you don't have that coverage in place anymore, if it was occurrence-based coverage, you're covered. If it's claims made coverage, you're not covered. And that's when you get into the issue of tail coverage. If you're leaving, then retiring, going to a different practice, you want to look at tail coverage. The reason occurrence-based coverage is more expensive than claims-made coverage, and most employers, most practices go with claims-made, it's cheaper because it's a lesser coverage. A lot of times incidents don't come up until somebody makes a claim later and the coverage may not be in place. And tail coverage can be very expensive. Tail coverage for some professional practices can be literally, I've seen tail coverage in upwards of $30,000 to $40,000 a year. for tail coverage for certain specialty practices. OBGYN is pretty typical. There's some other practices. There's a loud horn going off outside. I apologize if you hear that. In any event, that can be an issue that you definitely need to account for. Or if you're moving between employers, that becomes an issue as well. If somebody's coming into your practice, you may want to require that they have tail coverage, or sometimes we refer to that as nose coverage. You're joining a practice. We want to make sure that if you've been practicing on your own, you don't want to get sued, even though you probably ultimately get the case dismissed because you're not involved. You don't want to hire somebody, bring them into your practice. They get sued because something had happened a year ago, and because you're the current employer, you get dragged into that lawsuit. So that's something you may want to address when you're hiring people. Again, always a good idea to have a good insurance professional who's familiar with these issues and can tell you the coverages, explain the differences, and walk you through exactly what you need. On controlled substances, this is one of these issues where you need to be aware if you're prescribing controlled substances. Florida is very strict on what you prescribe. You have to go into the eForce database and check the patient. You need to document this. You go in, you have to get this set up as a prescriber and know that there's certain limitations in Florida. There's a very narrow windows during which you can prescribe opioids. Florida was known as a pill mill state for a long time. So we have strict timeframes on how you can prescribe opioids, and you need to check and make sure anybody you're prescribing isn't already in a database so that they're not going to two or three or four other professionals getting the same prescription. You need to document that. I like to say that when it comes to documentation, if it's not documented, it didn't happen. So keep that in mind. That goes for all of your issues with trying to get paid, your issues with prescribing. They're your big documentation issues. All right, now once the doors open, business starts rolling, your job changes. Now you have to make sure you fill the schedule. You have to be able to not only collect payment, but defend it once it's earned and keep the payments, respond to payer and regulatory issues, respond to potential complaints and issues. And then you have some good stuff. You may have inquiries, folks who want to invest, folks who will approach you about expansion or all the opportunities for growth and maybe some type of future exit. And that's the last thing we'll talk about here in step 8. Patient acquisition planning is essentially shapes the economics. Practices that plan well, you have a good channel mix, realistic timelines, defined budget. You fill your schedule predictably. The structural mistake to avoid is not whether you engage in marketing, it's how you structure the marketing arrangements. The structural danger is that marketing arrangements that often look most attractive are the ones that can create issues with anti-kickback and Florida fee splitting. And a lot of businesses, you could say, go out and get me customers, and for every paying customer, I'll pay you a percentage. An arrangement like that in Florida creates problems because it looks like fee splitting or patient brokering. What's a safer alternative? Typically marketing arrangements. And by the way, the lawyers are subject to the same thing. A marketing arrangement where you pay a flat fee for exposure, maybe a number of clicks, or or you pay some type of flat fee or fee that's based on fair market value of the services that's not tied to the value or volume of patient referrals. Always remember that the policy behind all of these rules is to reduce and remove incentive to get healthcare services based on financial incentives. And it's to reduce the use of healthcare services so that the only people seeking out those services aren't people who've been sold, it's people who actually need the services. All right. A practice that documents well and responds substantively often does well when it comes to audits and inspections. If stuff's documented poorly, you end up negotiating from a weak position and trying to cover your bases after the fact. I recommend that everybody have a compliance calendar. We work with clients sometimes to set these up so that you have a documentation throughout the year of certain items that you need to cover with respect to your audits, your HIPAA compliance, employee training, things that if you ever have an incident like a security breach, and I've just gone through this with a couple of clients, Uh, these are the things that you're going to need to be able to produce to regulators to show that you're engaging in good faith efforts to comply with the rules. Nobody expects you to be perfect, but what they do expect is that you're diligent in trying to comply and that you can demonstrate that after the fact. A couple common mistakes when it comes to uh, practice operation after you get going. One is, as I mentioned earlier, the percentage of revenue, the percent per patient, starts to look like, and this can be in the MSO arrangement as well that we can talk about, that starts to look like fee splitting, patient brokering, or gives you a risk of anti-kickback concerns. Another common mistake is assuming that your payer defense arrives when the audit letter, or starts when your audit letter arrives. Your payer defense, your audit defense against payers starts when you're documenting the services and you're documenting the records so that once you submit the billing and you get paid or you're waiting to get paid, if you're asked for the records have all the key language in them to support the billing and make sure you can get paid. So now, what's the next step? We walk through 8 different steps, and here's the things you can do as you go forward. So I get contacted a lot to work with people, sometimes from start to finish, sometimes piecemeal. So you have one option to work with an attorney or work with a professional to go through these pieces and set up the business. Another option is you can try to go it alone and work with information you get off the internet. You're going to have a lot of questions. We gave you a checklist so you can use that. And another option is we've now been starting to put together an 8-week cohort to help folks walk through all the steps that I just walked through in this webinar. We talked about the what, we talked about the why, things that are important, things you need to account for. Now, how do you do it? How do you address each particular step? And I've been working with a couple other professionals, credentialing expert, insurance, marketing, to put together a full course to walk professionals through. And if you have any interest in that, we'll do a follow-up email. And we're looking at launching our first one later this summer. And I'd love to see some folks participate in that. I think it would streamline things a lot. This is probably the question I get most often in my professional practice is, how do I get this stuff? What pieces do I need and how do I set up for a practice? And doing it on a case-by-case basis can be very tedious, very scary, and it can be very costly. Where if you do it in a group setting, you get set up on a regular calendar from week 1 to week 8, where you're ready to go at the end of the 8 weeks. When we do that, we're not going to give you just templates. We're going to walk through with you all the documentation, all the things that you need to operate the practice effectively. And the items that we'll cover here on the last slide. Look at that checklist that we gave you. It's pretty comprehensive. And if you have any further questions on that, please feel free to reach out to me or my office. I'll be happy to set up a follow-up with you. If there's any questions, I think we're right at 1 o'clock, so I appreciate everybody's attention here. Happy to field any questions before we jump off. Otherwise, I'd say thank you for spending the hour with me. And again, I encourage anybody to follow up either by email or through LinkedIn, or check out some of the other webinars we have online for medical directors or other issues that you see. Thank you.